The Constitutional Council is the highest constitutional authority in France. It was established by the Constitution of the Fifth Republic on the 4th of October 1958 to ensure that constitutional principles and rules are upheld. It is housed in the Palais Royal, Paris. Its main activity is to rule on whether proposed statutes conform with the Constitution. After they have been voted by Parliament and before they are signed into law by the President of the French Republic. Since the 1st of March 2010, individual citizens who are party to a trial or a lawsuit have been able to ask for the Council to review whether the law applied in the case is constitutional. In 1971, the Council ruled that conformity with the Constitution also entails conformity with two other texts referred to in the preamble of the Constitution: the Declaration of the Rights of Man and of the Citizen and the preamble of the Constitution of the Fourth Republic, both of which list constitutional rights. Members are often referred to as legislators in the media and the general public, as well as in the Council's own documents. Legal theorist Arthur Dive notes that this tends to make those who dare criticize them look unwise. The Council has two main areas of power. In some cases, examination of laws by the Council is compulsory. Organic bills, those which fundamentally affect government and treaties, need to be assessed by the Council before they are considered ratified to be adopted with decree of the Prime Minister. The redefinition of legislative dispositions as regulatory matters initially constituted a significant share of the caseload of the Council. In the case of other statutes, seeking the oversight of the Council is not compulsory. However, the President of the Republic, the President of the Senate, the President of the National Assembly, the Prime Minister of France, 60 members of the National Assembly, or 60 senators can submit a statute for examination by the Council before its signing into law by the President. In general, it is the parliamentary opposition that brings laws that it deems to infringe civil rights before the Council. Another task, of lesser importance in terms of number of referrals, is the reclassification of statute law into the domain of regulations on the Prime Minister's request. This happens when the Prime Minister and his government wish to alter law that has been enacted as statute law, but should instead belong to regulations according to the Constitution. The Prime Minister has to obtain reclassification from the Council prior to taking any decree changing the regulations. This, however, is nowadays only a small fraction of the Council's activity. In 2008, out 140 of decisions, only 5 concerned reclassifications. The government of France consists of an executive branch, a legislative branch, and a judicial branch. The judicial branch does not constitute a single hierarchy. For historical reasons, there has long been political hostility in the nation to the concept of a Supreme Court. That is, a powerful court able to quash legislation. Because of the experience of citizens in the pre-revolutionary era, whether the Constitutional Council is a court is a subject of academic discussion. But some scholars consider it effectively the Supreme Court of France. The Constitution of the French Fifth Republic distinguishes two kinds of legislation: statute law, which is normally voted upon by Parliament, and government regulations, which are enacted by the Prime Minister and his government as decrees and other regulations. Article 34 of the Constitution exhaustively lists the areas reserved for statute law. These include, for instance, criminal law. Any regulation issued by the executive in the areas constitutionally reserved for statute law is unconstitutional unless it has been authorized by a statute as secondary legislation. Any citizen with an interest in the case can obtain the cancellation of these regulations by the Council of State, on grounds that the executive has exceeded its authority. Furthermore, the Council of State can quash regulations on grounds that they violate existing statute law, constitutional rights, or the general principles of law. In addition, new acts can be referred to the Constitutional Council by a petition just prior to being signed into law by the President of the Republic. The most common circumstance for this is that 60 opposition members of the National Assembly or 60 opposition members of the Senate request such a review. If the Prime Minister thinks that some clauses of existing statute law instead belong to the domain of regulations, he can ask the Council to reclassify these clauses as regulations. Traditionally, France refused to accept the idea that courts could quash legislation enacted by Parliament. This reluctance was based in the French Revolutionary era. Pre-revolutionary courts had often used their power to refuse to register laws and thus prevent their application.